Welcome to another segment of King County Law Library's What to Expect When video series. Our guest expert today is the Honorable Judge Michael Finkel, who is a judge with King County District Court. And Judge Finkel is going to discuss five important pieces of information related to protection orders in King County District Court. Welcome, Judge Finkel.
Thank you for having me.
Happy to. So what about protection orders in King County District Court?
Okay. Before I get into the five areas, I want to tell you what my remarks are going to be and what they're not going to be. I'm going to give you explanations of part of the protection order statute. It's a very complicated statute, so I'll just give you explanations of part of it. For people who are seeking a protection order and or people against whom a protection order is being sought, these remarks should be helpful also. And I'm hopefully designed these to highlight the choices that you can make. The judge in your case will talk to you about the rest. What I don't intend to do today is give you legal advice. And what I don't intend to do today is to tell you what choices you should make, because those choices are up to you. So the first thing I want to talk about is, what kind of an order can a petitioner ask for? Well, as long as at least one of the types of orders available meet the facts in your case, you can ask for it. Most of the procedures in the protection order statute apply to all of the types of orders, and those are anti-harassment protection order, stalking protection order, sexual assault protection order, vulnerable adult protection order, extreme risk protection order, and a domestic violence protection order. Those are all defined in the statute. Can't really take the time to go over them here. You should read the instructions in the petition. They're long, arguably boring, but they will help you decide which type of order that you want to seek. Second question is, what county should I file the petition in? Well, there are some pretty straightforward rules on that. If you're a petitioner, you must file in the county where at least one of the following things applies. The petitioner resides, the acts occurred that lead to your filing the petition, a child is to be protected and they reside within that county, or the petitioner resided in the county before relocating to escape whatever the behavior is that they're seeking protection from. There are special statutes that deal with out-of-state respondents, and you need to take a look at those because they are very much case-specific. What happens if you file in the wrong county? Well, the court will either transfer to the correct county if it's a superior court, or advise you of what the correct county should be and dismiss the case if it's a district court. I could explain why, but that's probably a little more information than you want right now. The third issue I want to talk about is, should the petition be filed in district or superior court? Well, either district or superior court can hear anti-harassment protection orders, domestic violence protection orders, sexual assault protection orders, and stalking protection orders from beginning to end. District court can only hear extreme risk protection orders through the initial hearing. Once that initial hearing takes place, if it's set for a full hearing, it must be transferred to superior court. And only superior court can hear a vulnerable adult protection order. Some of the things you might want to consider in district or superior court is, which one is closest to you, which one would you prefer to be in, and whether the case has to be transferred over to superior court at a later point in time. And I'm glad I mentioned that, because that brings me to my next topic. If the petition is filed in district court, will it stay there? Well, a district court must, and that's must, not may, but must transfer a case to Superior Court if any one or more of the following factors applies. One, it's an extreme risk protection order petition and set for what we call a full hearing. Or if the Superior Court has exercised or is exercising jurisdiction over the parties. So if there is a parenting plan between two former spouses or things like that, or even if there's a land dispute between those same two parties, if the Superior Court had that case or currently has it, then it has to go to Superior Court after the initial hearing. If the effect of an order would interfere with a respondent's care, control, or custody of the respondent's minor child, then the full order has to be heard in Superior Court, even if the temporary or initial hearing is heard in district court. And notice that I said the respondent's minor child. So it has to be a child that is the respondent's. It can't be a child that the respondent simply has a relationship with. The case also must be transferred if it would affect the respondent's use of real property for which the respondent has a valid claim, or it would exclude a party from a shared dwelling. Sometimes people want to exclude a tenant from a residence. Well, that has to go to Superior Court. The full hearing cannot be heard in district court. If the respondent is under 18, the case has to go to Superior Court after the initial hearing. And if the district court is unable to verify if there are potentially conflicting or related orders between the parties, and this pops up quite often when the parties are having a marital dissolution and there might be a restraining order in the dissolution case. If the district court doesn't have a copy of it, we can't tell whether there's a conflicting or related order. Is the court required to set a full hearing? And I'll just explain. The initial or temporary hearing is the first hearing that happens after you file a petition. If the court sets it, you might be asking for a temporary protection order. So they're sometimes called emergency protection orders, but the technical term is temporary. So you might have a temporary hearing on that. The court has to set an initial hearing or make an initial finding whether the petition can be set for a full hearing. And here's where it gets, there's a technical term I'm going to give you, but then I'll tell you the real world definition of it. The petition must make a prima facie showing for at least one type of protection order. You might say, what does that mean? Well, based on the document you file under oath, do the words make out a case where the court could conceivably issue a protection order? And I'll just give you a quick example. If somebody wants an anti-harassment order and they only allege one incident, and that's all, an anti-harassment order, generally speaking, requires a course of conduct. So if there's one incident but no course of conduct, it could not make out a protection order. It would not be a prima facie showing. If there is a prima facie showing, the court is required to set the full hearing, either in district court or if it's a required transfer to Superior Court, then in Superior Court. If it does not, if the petition does not set a prima facie case for a full hearing, for anything other than an extreme risk protection order, the petitioner has 14 days to file an amended petition. If the petitioner does not file the amended petition, or if the amendment is still insufficient, the court is required to dismiss the petition. The petitioner only gets one shot at amending, and the 14-day period is basically, that's a mandatory cutoff date. For an extreme risk protection order, the court simply states on the record why they denied the extreme risk protection order, and there is no 14-day period. The rest of your questions should go to the judge in your case. Just remember, judges cannot give legal advice. We're supposed to know the most about the law, and we probably do, but we cannot give legal advice to either side. Every case is different, and every time a judge sees a petition, that judge looks at it brand new. There's no cookie cutter way of looking at these. They're all unique. If you want to look at the law yourself, you can find it at the Revised Code of Washington, Chapter 7, period 105. And if you use a browser and you search Revised Code of Washington, Chapter 7.105, you should be able to find the information that you need. I hope I've been able to give you some helpful information, and I hope that this makes you able to make better decisions and more informed decisions on how you want to handle your cases. Thank you for listening.